Good evening, everyone. My name's Jo Bragg. I'm the Chief Executive Officer and Solicitor at Environmental Defenders Office Queensland, your host for this evening. Firstly, I'd like to acknowledge the traditional owners of the land on which we meet and their elders past and present. I'd like to acknowledge members of the judiciary here tonight. I'm very excited with our two guest speakers tonight. We have the Honourable Justice Brian Preston, the Chief Judge of the New South Wales Land and Environment Court, who's made the effort to be with us tonight, and also Dr Justine Bell-James from UQ, who's been pretty busy lately with a lot of family matters, but it's wonderful that she's been able to be here tonight. But I'd also like to acknowledge all the many members of the legal profession, solicitors, barristers, academics, law students who've decided it's important, they want to be here tonight and learn more about climate change law. I'd like to acknowledge the volunteers who support the work of EDO Queensland in climate change and other environmental matters, and the staff of EDO. So really pleased to have each and every one of you along tonight. So I'm just going to be very, very quick, but having a captive audience, it is helpful for community legal centres so that people know a little of what we do. In terms of who is EDO Queensland, we are a community legal centre. We're a non-profit community legal centre. We are members of a national association of independent legal centres and part of the EDOs of Australia group. The sort of work we do is pretty similar to what other community legal centres do, in that we give legal advice to people within the community. We represent citizens and groups in relation to important public interest environmental matters in court. We also do law reform and we also do community legal education. So all those normal things that community legal centres do, we do, just in the public interest environmental law context. So as you can see on the slide, there's a number of areas in which we do the public interest environmental law work. Community rights, such as objection rights in relation to mining and big development proposals. We do work on the Great Barrier Reef and nature, taking initiatives to help the community better protect those areas. We stand up with the community for clean air, clean water and healthy communities. And in addition, we do policy and representation work relating to safe climate and clean energy. So here's an example of one of our evening advice sessions. So we do free legal advice to community members, be they farmers, coastal people all over Queensland who need help on public interest environmental law. There's no other organisation that is able to help people with this advice. We help farmers, such as the farmers out at Ackland, who are currently opposing an expansion of the new Ackland coal mine, particularly because of their fears about the impacts on groundwater on which they depend for their business. We do represent major conservation groups. So, for example, on the 3rd of March, EDO Queensland lawyers, supported by members of the bar, were in the full federal court on an appeal relating to the federal environmental approval of the Adani Carmichael mine. And a lot of those big cases and the law reform work does relate to protecting the Great Barrier Reef and climate change. Here's myself with Revel Poynton, our law reform solicitor, doing work in relation to the Barrier Reef and priority ports and dredging legislation. And we do things like compare and contrast different proposed planning legislation, different bills that go through Parliament, and trying to rate them, looking at environmental protection, social matters, and also community rights and transparency. And that's an example of a report card we put out in relation to planning, those different planning bills last year. We also do publications. You may have seen our Community Litigants Handbook now in its 4th edition, and I recall Alan Wilson, when at the Planning and Environment Court, was kind enough to write a foreword to that publication. We also have a Community Mining and Coal Seam Gas Handbook, which we're now needing to update. So this is all part of the community legal work that IDEO Queensland does, but we've certainly got a strong interest in climate change. So if you're interested to be more involved in terms of pro bono work, we're very, very keen to have your assistance. And if you're interested in not just the serious debate as we'll be having tonight on climate, but if you're interested in an entertaining evening, on the 5th of May we are having a major debate and art auction at the Queensland Law Society, and there's more about that later. So without further ado, I'll now pass over to your chair for this evening, the Honourable Alan Wilson QC.
Thank you, Jo. If you don't mind, I'll refer to you collectively as distinguished guests. In the past century, humankind and the world as a whole have faced several serious threats to our existence as a species and as a living planet. Totalitarianism has been one, nuclear war another. There is a widely and strongly held view that dangerous and potentially unmanageable climate change is another. The Paris Agreement, negotiated by 195 countries at the 21st Conference of the United Nations Framework Convention on Climate Change in December 2015, has the aim of holding any increase in global average temperature to well below 2 degrees Celsius above pre-industrial levels. It aspires to do this by focusing upon the greenhouse gases emitted by each nation party and placing agreed limits upon them. In effect, each signatory promises to do better and to continue those efforts over some decades, with the long-term goal of net zero emissions by the second half of this century. It is aspirational in many ways. The rich first world countries plan to provide billions of dollars in aid to developing countries to help them with both mitigation and adaptation. The accord is necessarily complex, multifaceted, of prolonged effect, and with a plethora of potential legal implications. It is to the credit of the IDEO Queensland that it is sought to help us with a program intended to alert and guide us in understanding these things. Our first speaker tonight, Dr. Justine Bell-James, is eminently qualified to do that. She's a senior lecturer at the T.C. Burns School of Law, teaching undergraduate and postgraduate courses in the areas of environmental and property law. Dr. Bell-James obtained her doctoral degree from QUT in 2010 and was awarded an ARC-funded postdoctoral fellowship in 2011. She undertook her postdoctoral research at the Global Change Institute, focusing on legal, policy and insurance responses to coastal hazards and sea level rise. Her research has focused on legal mechanisms for protection of the coast, drawing upon environmental, planning, property and tort law. She's the author of Climate Change and Coastal Development Law, published in 2014. She is particularly interested in the novel legal mechanisms for protection of coastal ecosystems like mangroves and seagrass, the protection of the Great Barrier Reef and biodiversity offsets in the coastal context. Her work is highly multidisciplinary and she has collaborated widely with researchers from across UQ's facilities and institutions. She will speak to the question, Paris, has the world been saved? Please welcome Dr. Bell-James.
Thank you very much. So I'll just take a moment anyway to say thank you very much to Joe and to Alan for those kind introductions, and thank you very much for the invitation to speak with such a distinguished panel. I'm just going to follow up on Joe's slightly cryptic remark and issue a bit of a disclaimer that this is the first time I've been amongst civilised company since my daughter was born 4 weeks ago. So if I'm a little bit incoherent, I haven't slept in a little over a month, and I'm really excited to be talking about something other than bodily fluids. It's coming. Anyway, while it's loading, so the topic I've been given tonight is Paris, Has the World Been Saved?, which is a pretty broad topic to speak to. And so to answer this question, I decided I would break it down into 3 different things that we need to talk about. So firstly, the context in which the Paris conference was held. Secondly, what actually happened in Paris. And then thirdly, thinking about what was achievable. And I think we're up and running now. All right, so the first thing to think about with Paris, as hyped as it was, it didn't happen in a vacuum. So we really need to think about the international law context in which it arose. And a lot of this is probably familiar ground to some of you, but to some of you it might not. So we'll power through quite quickly. So the international law context in which Paris started with, rather, is the United Nations Framework Convention on Climate Change, or the UNFCCC, which was entered into in 1992. And this agreement set out really broad objectives in terms of climate change action for country parties and encourage parties to take action on climate change. So that was in 1992. Since then, there has been a Conference of the Parties, or a COP, basically every year, and every COP, more or less, has had some sort of legal or non-legal outcome from it. So whether it's a binding agreement or whether it's just some sort of declaration that the parties have agreed to. So we've had this incremental progress occurring at the international level, and plenty also goes on between these COPs through subsidiary bodies. The next really important development to think about is the Kyoto Protocol that was entered into in 1997. And you've probably heard a lot more about the Kyoto Protocol in the past than the UNFCCC. And the reason for this is that Kyoto was the agreement that set the definite targets for country parties to aspire to attain. So Kyoto, in a nutshell, developed countries that were party to the agreement as a whole agreed to cut emissions by 5%. So this 5% cut as a whole was based on 1990 levels, so what those countries were emitting in 1990, during a commitment period of 2008 to 2012. So that's the time in which the commitments came into play. So basically, for each of those years, between 2008 to 2012, those country parties as a whole would emit 5% less than they did in 1990. There were some adjustments made to account for the differing circumstances of different countries. So, for example, Australia's figure for the commitment period was actually 108% of what they emitted in 1990, being, of course, that Australia's population had grown so much since 1990 that 108% of 1990 emissions would actually be quite a cut that they'd need to make. In contrast, more developed countries like Germany had more onerous targets, so 92%, but as a whole, 5% reduction. So Australia technically had a target that would require cuts to emissions, but if you're familiar at all with the context of Kyoto, you might have heard of the Australia Clause, as it's famously called, and not for particularly good reasons, which is that Australia insisted on emissions from deforestation being included in the 1990 figure. And this allowed Australia to reach their Kyoto target by regulating deforestation whilst actually growing emissions in other sectors, including fossil fuels. So not a really great thing to be known for. There are certainly some good things about Kyoto that I'm going to come back to later when we talk about Paris. So I think the really good thing about Kyoto is that it set a really definite target, 5% cut in emissions, that's pretty black and white, so that was good. And it gave the parties something very tangible to work towards in that particular respect. That said, there were a lot of drawbacks associated with Kyoto. So the 5% reduction in emissions wasn't particularly ambitious. Bearing in mind this was an agreement entered into 20 years ago now. Certainly now, in present-day times, it's not particularly ambitious. In our Australian context, as I said, Australia could grow its emissions in the energy sector and still comply with Kyoto, so that's obviously not a great outcome either. It was also pretty hazy under Kyoto what would happen with non-compliance, and we saw this play out in the context of Canada. So Canada wasn't going to meet its Kyoto targets, so Canada's way of dealing with that was just withdrawing from the Kyoto Protocol immediately before the end of the commitment period, and therefore escaping any punishment. Punishments are a bit hazy anyway. So Kyoto, good start, definite target, black and white target, but quite flawed still. Successive COPs went on from Kyoto, and the next one you probably remember hearing a lot about is Copenhagen in 2009. And the reason why there was so much hype around Copenhagen was there was this push towards achieving a binding agreement for post-Kyoto, because as we said, that only operated until 2012. But as you might remember, the conference was marked by disagreement amongst the parties, particularly on the roles of developed versus developing countries, which emerged as a really major issue throughout the negotiations post-Kyoto. So no binding agreement was reached post-Copenhagen, but I suppose it was successful in that there was a lot of public awareness raised, and it really was probably the heyday for climate change awareness and public protest around climate change issues. So that was Copenhagen. Didn't get a binding agreement there, so that's when focus really turned on Paris as the important COP to look towards, with a goal of restricting warming to 2 degrees relative to pre-industrial levels, as was said before. Sorry, it's just a bit slow moving. I think it's going. There we go. Okay, no, we're good now, thank you. So the legal approach, I'm going to focus in on Kyoto as our comparator here. The legal approach from Kyoto to Paris really shifted. So while Kyoto was what you call a top-down instrument, so it was decided at the top what the country parties would do, and this then filtered down to their country-level commitments, Paris was really bottom-up, as was mentioned in the introduction. So rather than having a target imposed upon parties, parties have made their own commitments, which then form the basis of the agreement. So leading up to Paris, countries were invited to submit what were called intended nationally determined contributions, or INDCs. And what an INDC essentially was a pledge outlining what actions the party intended to take domestically to reduce emissions. They were encouraged to do this in the first quarter of 2015, and the idea was that then these INDCs would all be added up, and that would give us an idea of what would be tracking towards in terms of a degree of warming in the future. So this figure on the screen shows the INDCs that were submitted in this first quarter of 2015, so by April. And what the calculations showed is that the emissions reductions pledged by parties at that particular point in time would, when combined, restrict the global average temperature increase to 3.5 degrees by 2100. Okay, so falling well short of that 2-degree goal, certainly better than the 4.5 degrees we would have seen under a business as usual trajectory, but certainly well short of that 2 degrees. So that was the first quarter. Some parties didn't do what they were supposed to do and submit in the first quarter, including Australia. So Australia submitted in August 2015, and the pledge that Australia made in its INDC was an economy-wide target to reduce greenhouse gas emissions by 26 to 28% below 2005 levels by 2030. Okay, so that was Australia's target, which I'll come back to later as well. And by the time COP21 arrived in November 2015, when they added in these latecomers to this particular figure here, the aggregate of all INDCs would limit warming to an estimated 2.7 degrees by 2100. Okay, so we've gotten a little bit better from that 3.5 target, but again, still falling short of that 2-degree target that's sought. I just wanted to take a moment to think about why 2 degrees. Okay, why is this, that magical number that was latched onto for the negotiations? The 2-degree goal is actually based on what's now fairly dated scientific literature, which identified 2 degrees above pre-industrial levels, which is an important factor to consider, and I'll come back to later, as a so-called safe level of climate change. The idea being that beyond 2 degrees of warming by 2100, many climate change impacts would be catastrophic, and some systems would struggle to adapt. So 2 degrees, we'll see some changes, we'll see some negative impacts, but it's more or less okay, was the idea. So this graph on the left side is from the 2001 Intergovernmental Panel on Climate Change, or IPCC, assessment report. And the line tracking across the figure here shows 2 degrees of warming and impacts across 5 different scales. And what you can see in the figure on the left is that while 2 degrees isn't great, it isn't catastrophic. Okay, so that's really the figure that was based on, this latching onto 2 degrees in policy. So it's not great, but not catastrophic. But what we can see in this updated graph on the right, which is from 2009, is improved science, which shows that 2 degrees actually would be quite catastrophic in a lot of sectors. Okay, so the 2 degree target is actually quite dated in this respect, and if we do have 2 degrees of warming by 2100, the impacts will actually be quite a bit worse than initially thought. Despite this, 2 degrees has been officially adopted by the UNFCCC back in 2010 as the goal to work towards, and it's been used by a lot of other policymakers domestically as well. And I suppose like that 5% reduction in Kyoto, it is useful to have something black and white, some simple and definite target to work towards in policy making, but that said, that target really needs to be appropriate and achievable. Okay, so that's the road to Paris, which was quite long, hence the slightly lengthy introduction, and there was lots of preparation along the way. So what was ultimately agreed to in Paris then? The essence of the Paris Agreement is encapsulated in Article 2 of the agreement, which is the objectives. And there's essentially 3 pillars to the Paris Agreement. So firstly, climate change mitigation. So holding the global average temperature increase to well below 2 degrees above pre-industrial levels, with an aspirational goal of 1.5 degrees Celsius. A few interesting things to think about here. So firstly, we're looking at targets based on pre-industrial temperatures, and I believe at this point in time we're already heading to warming of around about 1 degree above pre-industrial temperatures. So if 2 degrees is our target for 2100, we're already halfway there, given that we're basing our figure on pre-industrial levels. And I'm also going to come back to that aspirational goal of 1.5 degrees shortly. Okay, so that's mitigation, the first pillar. The second pillar of the Paris Agreement is adaptation, which is encapsulated in paragraph B there. So adaptation is increasing the ability to adapt to the adverse impacts of climate change. So this recognises that some impacts are locked in or unavoidable, and changes will be needed to address this. And this was actually quite a landmark feature of Paris. So there's traditionally been some reluctance at the UNFCCC level to include adaptation in climate change agreements because of this perception it would be seen as defeatist. Okay, so we're admitting defeat, why bother with mitigation? By the time we got to Paris, there was a slightly more reasoned view of things, that there will be some impacts, we need to deal with that, but also try and do our best to mitigate climate change as well. And importantly, if we look at Article 2, the Paris Agreement really places adaptation on the same normative level as mitigation, so that's really important. And finally, the third pillar in paragraph C is finance. So a big part of the agreement is developed countries providing financial assistance to developing countries to comply, and that's something I'm not going to go into in too much detail tonight. Coming back to this idea of 1.5 degrees, because I think this is really important. So, as I said, 2 degrees had been early identified in the scientific literature as the safe level of climate change. It was adopted by the UNFCCC as the goal to work towards. But ultimately, what we ended up with in Paris is this aspirational goal of 1.5 degrees. So why is that? 1.5 degrees emerged in the lead up to Paris as a more appropriate goal to work towards, with a lot of the lobbying for this target coming from low-lying Pacific Island states like Tuvalu, the Kiribati and the Marshall Islands. The 1.5 to stay alive slogan gained momentum following Copenhagen in 2009, with the Association of Small Island States arguing that many of its members, like the countries I just listed, cannot withstand 2 degrees of warming. So the decision whether or not to include 1.5 degrees as an aspirational goal in Paris became one of the biggest issues leading up to the conference, and its ultimate inclusion is viewed by a lot of people as a really great success. So why is 1.5 degrees so important to these countries like our Pacific Island neighbours? These low-lying countries are projected to be disproportionately affected by climate change impacts like sea level rise. So because these countries are so small and so flat and low-lying, there are very limited adaptation options available. So residents might seek to relocate, they might seek to gain refugee status in another country. And escalating climate threats have, in fact, already led to refugee claims, but individual claims might be unlikely to succeed in the short term. So in 2009, a Kiribati national sought climate change refugee status in New Zealand. And his very long legal battle finished in 2015, with the claimant exhausting all avenues of legal appeal and ultimately being returned to Kiribati. And the Supreme Court, which is New Zealand's highest court, held that while Kiribati undoubtedly faces challenges, the claimant does not, if returned, face serious harm within the wording of the Convention, and there is no evidence that the government of Kiribati is failing to take steps to protect its citizens from the effects of environmental degradation to the extent that it can. Okay, so things aren't quite bad enough yet for residents of these countries to claim refugee status. On the flip side though, once climate change impacts do cause serious harm within the meaning of the Refugee Convention, refugee claims may be more likely to succeed. But I suppose the question we need to ask ourselves is, do we want matters to get to this stage before we intervene? So for example, some scientists have attributed the Syrian refugee crisis to drought exacerbated by climate change, which has in turn led to extreme violence over scarce resources. So I think that's the question we need to think of. Do we want those sort of situations before these claims are recognised? Outside of the refugee process, though, there are other avenues for countries, and some Pacific Island states have chosen to take matters into their own hands. So in 2014, the Kiribati government purchased 20 square metres of land in Fiji, almost 2,000 kilometres away. And the intention is for part of the country's population, if not all of their population, to eventually migrate to this location when climate change impacts become unbearable within their own country. And I think, thinking about this sort of decision that's being made at a country level, it is easy to see why leaders of these low-lying countries become really frustrated with the slow process of these international negotiations, because you've got countries like Australia and Paris really trying to protect their economic industries like mining, whereas these countries were really fighting to protect their citizens and their sovereignty and their cultural identity. So very, very different battles that were being waged at Paris. So 2 degrees will be catastrophic for low-lying countries in places like the Pacific. It could also be catastrophic for places like Australia as well, looking much closer to home in places like the Great Barrier Reef. Unfortunately, this graphic isn't working on this computer. It's quite a nice time-lapse that was put together by one of my colleagues at UP, Professor Ofer Gulberg, and it was an experiment that he did where he puts coral in these little sort of micro-environments and runs different scenarios under it. And what we would see with both the Paris Agreement trajectory and the business-as-usual trajectory is the coral would be in a much, much, much better state under the Paris Agreement trajectory than business as usual. If I was able to flip through those photos, the coral would be pretty much under the business as usual trajectory. Okay, so failing to cut emissions to the level contemplated by the Paris Agreement would be catastrophic for the Great Barrier Reef. There was also another recent study published in Nature in late 2016 that suggests that if we proceed with business as usual emissions, sites like the Great Barrier Reef may experience bleaching every year by 2043. So those really, really high profile and catastrophic bleaching events that we've seen could happen every year, which is obviously going to be really detrimental to the reef's ability to recover. But what this study also showed is that by implementing the Paris Agreement commitments, we could delay this by up to 25 years. Okay, so what this shows is that even much closer to home, our reef really needs the Paris objectives to be implemented. So restricting warming to 1.5 to 2 degrees is critical. 1.5 degrees would be better. And the Paris Agreement has enshrined this aspirational goal of 1.5 degrees, so that sounds really good. But has this saved the world? To answer this question, I think we need to think firstly about whether this target is even achievable. And given that we're already around 1 degree over pre-industrial levels, 1.5 degrees seems fairly unlikely. Research has suggested that under business as usual projections, we're going to pass 1.5 degrees by 2024, with the 2 degree target not much further in the future at 2036. Okay, so we've got very, very, very little time if we want to stay under that 1.5 degree guardrail. In fact, some scientists have suggested it will be impossible to keep warming below 1.5 degrees at this point, and that the feasible option is to overshoot this target by as little as possible, and then employ carbon removal technologies to remove CO2 from the atmosphere. Many of these technologies, of course, remain speculative or unproven at this point in time. So while this 1.5 degree target is global and really is a nod to these very, very serious problems faced by our Pacific Island neighbours, it's inherently flawed. Okay, so we've got a target that's flawed. Unfortunately, we have a potentially flawed mechanism to reach this target. So there's an inherent disconnect between the target, as it's articulated in Article 2 of the agreement, and the obligations placed on the parties. So I mentioned before the INDCs that were submitted prior to Paris. This INDC mechanism was implemented into the Paris Agreement with the intended drops. Now they're just NDCs. And the NDCs are the mechanism by which the objectives of the agreement will be pursued. So parties are required to submit NDCs outlining their domestic emissions reduction contribution it intends to make and the mechanisms that will be used to pursue this. And a new NDC has to be submitted every 5 years. The only requirement for an NDC is that it needs to be ambitious, which is obviously quite an ambiguous term, and that each successive NDC represents a progression on the previous one, which is called the ratchet mechanism under Paris. Okay, so countries basically make a pledge as to what they're going to do, it has to be ambitious, and they have to do better next time. There's no guarantee though that these country-driven NDCs will get emissions reductions to the level needed, being 2 degrees. And remember that the commitments that we had pre-Paris would only track us towards the 2.7 degree increase in warming. So we still have quite a way to go. So if we compare Kyoto had a relatively weak objective, being a 5% reduction in emissions, but a fairly strong top-down approach for meeting this target. In contrast, Paris has a very, very ambitious target, but the bottom-up approach to meeting it relies very heavily on the cooperation of the parties. And I suppose the other interesting thing to think about is compliance. So there's really no mechanisms in the Paris Agreement to punish failure to adhere to NDC commitments. So even if we do have parties making really ambitious, really strong NDC commitments to do things domestically, there's as yet no mechanism to punish these country parties if they fail to comply. So perhaps even quicker than Kyoto in this regard. So to sum up, 1.5 degrees would be great, but may not be feasible. 2 degrees may be feasible from a capability perspective, but may result in serious impacts anyway, and may not be achievable under the NDC mechanism. So is the world saved? Probably not. A better question, and perhaps a more optimistic one to think about, might be, was Paris successful? And even then I think we need to answer that like lawyers and say it depends on how you define success. So in many ways Paris was successful. A binding agreement was reached. It involved major developed country players like the US, just leaving aside what's happened in the US since then, and developing countries as well. The target of 2 degrees with this aspirational goal of 1.5 degrees was based very heavily on science, which was really important and a really big development at that level. So in these respects, yes, it was successful. There were a lot of really good features to Paris. And I think we also need to remember it was a product of compromise. So we were never going to get countries to sign up for a rigorous top-down agreement. So in that respect, it was successful also. So the big challenge is going to be getting commitments from parties that are strong enough to bring us below 2 degrees or 1.5 degrees. Secondly, getting these commitments implemented and adhered to, and also finally being mindful that in doing this, we're really fighting the clock. So really it's up to all countries to do their bit to save the world. And as much as Paris was a global effort, the success of the agreement depends entirely on local efforts. So this leads us to our local context, being mindful of time. Is Australia doing its part to save the world? So as I mentioned before, Australia's INDC commitment was to reduce emissions by 26 to 28% by 2030 based on 2005 levels. Putting that in the context of other countries, it's a bit less than other OECD countries. So Canada, the US and the EU have targets in the 30s, other European countries in the 40s. So our target is a bit lower than other countries, but probably not too bad on a comparative basis. Although, as we know, these targets that are being pledged by these countries aren't enough to stay within the 2 degree target. But hopefully we'll have more ambitious NDCs in the future. Probably the bigger question for Australia at this point in time is whether we're going to meet our current and imperfect target. And this is really dependent on what mechanisms are taken domestically to combat climate change. So at present, the federal government's main climate change policy is the Emissions Reduction Fund, or the ERF, which is a reverse auction scheme, so proponents of clean energy or emissions reduction projects bid for government funds. And the federal government essentially buys these emissions savings based on the sole criterion of price. So basically the projects which provide emissions reductions at the lowest cost per tonne of CO2 are purchased. So $2.55 billion was allocated to this fund at its inception. The money has really run out, it might have even run out in the last auction, and further funds have not yet been allocated. So on the right of the slide here, I've got some modelling produced by the, unfortunately now defunct Climate Institute, which suggested that the funds currently allocated to the ERF would only be capable of purchasing 14% of Australia's Paris Pledge. And only 7.5% of what would be needed to keep warming within 2 degrees. Okay, so there's no way under our current approach we're even going to do what we pledged to do under Paris. So I think it's fair to say that no, Australia is probably not doing its part to save the world. And unfortunately, as I said, the Paris Agreement really isn't equipped to deal with this situation. So any compulsion for Australia to do more has to come from a moral, ethical, or reputational imperative to do more. And it's not just on a pure domestic level that Australia's commitment is lacking, it's also on Australia's contribution to emissions elsewhere. Some of you, particularly those of you that have followed the EU's litigation, might be familiar with the carbon budget and the research underpinning this. So it's an amount of CO2 expressed in tonnes that we globally can emit and stay within 2 degrees of warming. So if we're to meet the carbon budget and not overspend, it's clear that a significant amount of fossil fuels, and coal in particular, needs to stay in the ground. And despite this, as we know, Australian governments are pushing ahead with many new coal projects, including the very controversial Adani Carmichael megamine. So some analysis that was undertaken by the Australia Institute, which is the graphic on the right, showed that emissions resulting from this mine, even if they occur and are therefore accounted for offshore, will essentially cancel out Australia's NDC commitment. Okay, so even if Australia does do what it said it would do in Paris, which it's currently not tracking to do, this will effectively mean nothing if Carmichael goes ahead. So is there any good news? I'm really sorry to make this quite doom and gloom at the end, so let's try and finish on a happier note then. I was fortunate enough to attend COP21 in Paris, and the feeling I left Paris with was ultimately optimism that this problem could be solved, but not necessarily by governments or through formal mechanisms. And what I think we're seeing a lot of now is progress in the private sector, in NGOs like the EDO, in the community, and also in the new generation that's coming through. A lot of my students, next students sitting here tonight. So if we look at Carmichael as an example, whilst Australian governments seem really keen to push ahead with this project, we've got major banks that are reluctant to finance it, we've got NGOs and community groups that are united to fight it, and we've got an overwhelming majority of the younger generation opposed to it. We have technologies like renewable energy becoming progressively more feasible and cheaper, to a point where using greener technologies will make sense on a pure economic basis, leaving aside many of the environmental benefits. So all of these developments outside of the formal legal process are happening as well, and they really can't be underestimated. And furthermore, despite what I've said tonight, I really don't think we can completely write off progress that occurred through legal process and in Paris. I don't think we can say Paris saved the world, but I think we can definitely say it was successful. Again, being mindful of how we define success. It united world leaders, and getting an agreement on climate change involving all of the global community, however flawed it might be, is really monumental and something that we do really need to be proud of. The NDC mechanism, while it is problematic, as I said, has set a really clear path for further and more ambitious progress to occur. And the integration of science into law, I think, is something that we really also can't discount the importance of. It's really, really important that we've now got 2 degrees, aspirational goal of 1.5 degrees, as our target, really, really grounded in science. So I think we as a global community on the whole can probably be happy with what occurred in Paris, but we must be really, really mindful of how much work remains to be done at a domestic level. And continuing to put pressure on governments to do this is important, and the work done by groups like EU Queensland is really crucial in this regard.